This one took it, fired from him. Who were also in the army, present in the army. Actually, it was a case of blind. Who has committed this murder? And thereafter, and thereafter, this and his court of inquiry was at his.
Witness have said that he was at the center, but will that apply to the second appellant? Is what I'm asking.
No, it won't.
That is
As far as the alibi is concerned.
4 weeks. Have you made the complaint as party?
Okay. No. Not party.
You to give the first informant as party is important. You should notice of standard level. By of identity orders, the judgment and by way of identity order, the judgment and order of the High Court state directed to be identity bail on the same terms and conditions. Whether you are on bail during trial?
No, my lords, they
No,
are.
I did not.
During trial.
Sorry.
My lords,
I was inside, therefore,
On such
my
complaint.
lords, if I make a permission, if my lords are granted bail, may.
It will hear you after.
My lords, if you're granting, may keep it for next week. We may engage a senior to assist the court.
That won't make any difference. At least in this court.
My lords, may please keep it for next week then.
Leave granted. The judgment and order of suspension. And sentence is stayed. Argue it after.
My lords, may grant us permission.
What do you want? You want to notice or leave?
Leave. Notice.
File your reply.
Much obliged.
One password.
okay. What is this?
He's on his legs, madam. Can we pass on at the end of the list? I'm sorry for the inconvenience, boss.
There's nothing in the market. Anyway, yes.
Entire transaction explaining what, because the High Court doesn't other form. Yes. The allegation is which now the High Court does or a status report with respect. Within 2 days that treat with the aspect that the money has come back, which has come back to this bank, which is to pay off some other loans. Please see, my lords. My finance is this. EMI Limited is the bank. SIPL, this SIPL is the company in which I, as the Abhicom, has 85%, no management control. It comes from this DMI Finance. It goes to this Keystone Developers, who is the builder to construct for this company SIPL. Money comes from there, and on the side I said he diverts the loan to Keystone for 33 crores. This Keystone in turn gives it to his own company, which is 33 crores. Stellar Spring gives it back to DMI Finance. This 33 is the diversion that we allege. And this proof is there, my lords, because the High Court, with respect, as I submitted to before your lordships, did not consider calling for either a status report from or counter affidavit from the state. Had it been done within 2 days of this quashing, my lords, the police filed a charge sheet. Of course, they could file charge sheet against all the people appearing on the other side. 4 persons, and it is replete with that how this takes place. Now, I am in a quandary. If those four have to be proceeded and they are in conspiracy for diversion, then the ultimate beneficiary of that, those funds that were being diverted to will have to be there as the accused persons. Now, with respect, Manoj, it was incumbent upon the High Court, Manoj, to call for at least a status report when the case had been, the FIR had been registered, Manoj, as far back as, Manoj, 2021.
Come to para 40, page 45, para H.
The two letters, first sanctions letter of DMI Finance dated 2/5/2008 and second the shareholders agreement cannot be held to be false document as informant in these documents after undertaking contents and signing the same and actually taken benefit in terms of these documents and loan amount of 55 crores and 9.80 crores was disbursed to the informant and the companies of accused A1. Once the informant company itself has signed these documents and after acting upon the same has taken huge amount on the ground that these are false documents is misuse of the process of law and is a novel way to avoid repayment of loan to the informant company. Therefore, 46871 is not made out against petitioners A to 5 in view of the decision of Bharatish Reddy versus Lalit Chaturvedi. Now, the allegation is that my learned friend I'm sure they are eager because I read everything. That this is yet another aspect that which the chief passing the interim order did not notice that the dispute.
You are reading?
I at page 46.
I, James, notice a clear breach.
This is the another aspect of which I'm reading it. My learned friend has some patience. I'm reading it. There's yet another aspect. Magistrate, while passing the interim order, did not notice that the dispute is of civil nature. And from 2018 to 22, when FIR was registered, the informant itself was acting installments from DMI Finance, and after 4 years, the present FIR has been registered against DMI Finance as well as other co-accused, and therefore the interim order passed by administration against the FIR is not sustainable in law. That's exactly the point. Now, please turn 100 of the additional volume. Now, my learned friend will read all of that.
I started NCLT proceedings and they went and ran on to
J he should have read, bro. J is very clear, NCLT should have read.
Can I complete my argument? So my learned I am not dependent upon what I can add.
So far as I am concerned, I am a lender. I have a
crores through the other company to pay off some other loans. Please see page 100.
After the NCLT, you come into this.
I don't understand why my
and he's not moving this building.
Why is
And now we're getting my argument.
Why is my learned friend interrupt me? I have not finished my arguments. Only you get a start.
Absolutely bogus.
Yes. This one doesn't mean it's bogus. But different contents.
We didn't have any fireworks in the morning.
I'm sure.
Yes.
Mr. Luthra was physically present.
Nobody's there.
He's hidden himself.
I'm here. I was here in the first call when you were missing.
Those different contents, page 100. Now I am only showing Manoj, if the High Court, if the FIR is of 22 and the judgment and the order of pass is 31A, surely it could have been called from the state as far as the program is concerned. And if it the allegation and the investigation has found that of loan of the money of the installment that will go back from the loan that I have paid, that entire 30 to DMI from another entity. That is what is in the charge sheet below, which is what my learned friends clients don't want to come. That is the difficulty. One. I'll show from repeat with the charge sheet.
One
Yes, please see 101
of the
additional the charge sheet that I have taken after. It's filed within 2 days of the court order below. That means the charge sheet was ready. Police was going to file that charge sheet below, and the High Court.
no, it is there. It is there.
And then one of the additional documents.
This is the charge sheet note which we filed. His diary which is annexed. And this is the client, and learned friends are all represented.
101.
101 crores. And I will take various other for whom they appear. I have disbursed a loan totaling to 23.88 crores till 31st March. However, as per AFS dated 31/3/2019, interest during construction is 23 crores 18 lakhs. Proves that 60 lakhs has been diverted by the borrower with connivance of DMI Finance. Save the work order in favor of Keystone Developers Contractors says all work shall be executed by the contractor, but scrutiny of books is 1 crore 17 crores 59 lakhs are in bills which have been raised by the contractor. Hence, balance of 559 lakhs is misappropriation of funds which may be. So this is the finding in the charge sheet, the allegation specifically. Now please see 108. I may only.
Case diary details.
Yes, it is case diary.
No, but you show the summary in the chart sheet.
But
That is not a part of charge sheet.
here it is 5.
On the contrary, the case
UP it is peculiar.
for the purpose of the investigation purpose, and nobody else except the court is entitled.
The charge sheet.
Oh my God.
This is part of the case diary. It is why everything. But I may request my learned friends' comments to be a little either low so that much as he wants to, but I allow me to argue. That prayer is to your lordship. So this is part of it. This is
You show the charge sheet.
all in the charge sheet.
The gist of the
Charge sheet says no case against him. No? Hindi version charge sheet says no evidence against me. Page 29. Page 29 it says suspicion approved nahi.
Page 20.
29, not 29 in the charge sheet. Please see, even against Shiva, suspicion approved nahi. Please see the Hindi version, Roman 11.
I may put it smartly saying, against these 4 persons, each 2.
साक्ष्य के अभाव हैं.
So obviously
29 and 30.
I mean, here I am
Column
showing-
14.
Point out from the summary to what is.
Just see column 14 at page 30 block. Just see column 14 page 30.
Is correct that this case diary is charge sheet or not. This is how we had it once it was filed along with the charge sheet. The case diaries are filed. One paragraph there, which your lordships have also noticed about and past various of Uttar Pradesh, Madhya Pradesh. Uttar Pradesh, Madhya Uttar Pradesh. Now I have one prayer. That will thus come in the trial. This order will under 319. That clarification the lordships. Excuse this court may.
Sorry, we are not inclined to interfere with the impure orders. However, in the event during trial, any material comes against the accused discharge,
Needless to say.
the High Court would not come in the way of any proceedings that any of the
The accused against whom caution.
Any person.
or father of any person.
But for them, the findings are there. So
But that has also been separately settled. No?
it has, but again, the moment 319 comes, the High Court caution that couldn't be summoned because.
No, but that has been
That can
settled. It has been held that notwithstanding wash or discharge, 319 can be independently applied.
In fact, 319 doesn't. 300
Yes.
for a discharge doesn't apply. But for a common caution.
Item 13 and like that limit. Possible.
No, this is some.
The application for it was listening of seven to judgment.
AG, the password are legal.
Also, the age is out.
AG is what appearing to password.
Okay.
Yes, sir. Application.
Lordship, there's a joint application filed. I'm appearing online for the petitioners in 2 SLPs.
Oh, we have.
Lordship, there are 3 SLPs filed against the
Complainant, my lord.
Long settlement.
Yes, my lord. My lord, because my lord, that likely commercial, my lord. So my lord, we
Yes.
are not settled. Wish to, my lord, I mean, my lord, it will be over.
I can point out pending proceedings where it's listed. It's at page 28. The
What are the sections in?
Lordship 420, 406.
Criminal MP number 253839. Settlement agreement dated 17th of July 2024. Is taken on record. The agreement are treated as an undertaking. In view of between the parties, the FIR number so and so, dated so and so, plans regulars.
Lordship, just wanted to point out that there are 3 SLPs pending. The petitioners in the first 2 SLPs are the ones that have settled. The third SLP has, and the complainant, I've been told, has no if the FIR is quashed even
My lord,
coherent.
he was a mere informant, my lord, in the sense, my
Which are
lord, it's in the joint application that the parties have filed, my lord. Stick today. Let's start.
it is in SLP number 15546 and 47.
The third one, SLP 3574 of 2024, that is by that intermediary. That is, however, not listed today since he's an intermediary.
We will list it somewhere in the next week.
Yeah,
Yes.
Your Lord-
No, we have no grievance in there.
Yes, my lord.
yes, no grievance. I was just pointing it out for your lordships.
He was merely a middleman, my lord, who introduced me to the applicant, my lord, the financial.
SLP number so and so is taken on board. Who is the petitioner there?
Well, the petitioners, Mr. Vishal Satinder Sood.
You know the petitioner in there. Oh. Let it be listed in the next week.
No,
Give the number, we'll have it in the next week, yes.
okay.
Yes, your lordship.
Lordship, item 15, I beg to the state of Bihar, Lordship. I'm requesting 2 weeks accommodation to file counter affidavit, Lordship.
Our instance for an order dated 17/5/24, by which is court.
Let them file reply.
Please, Lord, even in the counter, I did many new facts and annexed many new documents. In fact, the office.
Listen, matter is heard finally.
Some
Can't
sort,
be- can't be vacated now.
it may be heard some.
I'll file reply to the application member,
Because,
and they should. Affidavit, because
yeah, because the respondent number I had already overaged.
Okay, let him file that.
Much of your lordship.
Some date when
Take it after it.
See,
some sort of date, your lordship.
Order can it be unless
I have to write.
It's 1960, your lordship said heard us and granted. Petition has been
Excellent, excellent.
been given default bail in the matter. They will file. Have been granted default bail by the tribunal.
Yeah, months.
March 3rd.
By 3 months. Really fair.
You go consequently, you could see that. We'll have it for evening in the immediately after.
for weeks to be heard.
Granted default bail in this FIR. The entire on the FIR have been granted default bail.
They have to counter on this because you want a challenge in this very petition, so that is understandable. So they need to
Itself.
for the extension. So grounds against the extension.
Once there is a judicial order granting. They have not even filed the charge sheet now for 8 months. But your lordships are well that even a charge sheet can't be used to deny default bail. To use preventive detention to deny default bail.
The application to be considered along with the appeal. We preemptively posted for hearing on
Almost 9 months.
this is the when.
Please. Item 42. Accommodation in. I got the file day before yesterday only. I recently filed the Wakalatnama for
How do you brother's evidence?
your
Get in-
Your lordship, I have to see the trial court record. Actually, I have recently filed the Wakalatnama.
Okay, March meeting.
Next,
Your lordship may give me 2 weeks here, lordship. Because I have from trial court.
You not even at how the evidence of that Ganga
Yes,
Vishnu is not Vishnu.
Which has been filed in the SLP is there is evidence of they are the person who first saw the victim. And
okay. Recurring cases. In fact, if I may hand over a compilation, my how can it be, my lord, she says 6-7 years, there's consensual. How can it be 376 to N?
Your lordship, I am for complaint.
You'll have it on some NMD test. You'll have it on my NMD. Requested, I am told that he's posted as a PA in Kashmir right now. And no.
Charge sheet has been filed.
No question.
Your lordship, something.
Yes.
He cheated my lot around this family lordship, and due to very uncomfortable in my
He
society.
has raised a point about false promise and bona fide promise which could not be put.
Your lordship, he made on a stamp paper that he will
month. After that, he married in another girl, let's say.
Put on a NMD after vacation. No courses will be taken against.
Here for the respondent number 1. See instructions, however, upon a overview of the case details, it appears unit number 1 husband has been acquitted. So this is as per our
Research. Then what?
also for and also no incriminating evidence because the complainant failed to prove this.
No, but the trial have not concluded.
The learned counsel for the state
But my love, they may clarify on that.
informs that the trial is already in which the main accused, that the husband of the present has also been acquitted. The learned counsel in that regard.
We can also seek further instructions.
Mediation.
Hey, what mediation? If the trial is already over, what mediation?
Madam, watched against the other.
2 months he was
Put it after 4 weeks. Physical evidence.
Yes.
Item 45, appearance of the respondent. Madam, we filed the counter yesterday. Madam, we given you a week's time. We already filed.
Have it next. Focus sentence is 12 years. He has already undergone.
Next week.
This is the case of when petitioner counsel has not appeared before learned trial court officers who have extorted and beat him and filed a false case against. Even respondent state has filed a counter affidavit admitting this fact that I have emailed to superintendent police, but they have done an investigation without issuing notice to me. So I filed a complaint before. The complaint was dismissed on non-appearance of petitioner counsel. Thereafter, Lordship petitioner is approached learned session court. Session court has granted approach learned trial court magistrate, but the magistrate has again then your Lordship petitioner is challenged before Honorable High Court, and Honorable High Court has again my only contention, your Lordship, is that the complaint is still to be adjudicated, and your Lordship, is a singular default. Your Lordship judgment, your Lordship may remand the matter back to trial court. These officers who have been entered appearance. Respondent number 2.
Argument has concluded the inquiry. The inquiry, after inquiry, this has been intimated to the honored petitioner. That's they had made a complaint against some police officers. The police officers on 13 September 2007. Email. There's a separate for the different district police officer, additional superintendent. Inquiry.
What has been found in the inquiry? What has been found in the inquiry?
There's nothing at page 79 months. Page 79.
In the regional also, the lordship, that they have not even issued the notice to the circle. The inquiry has not even asked me to join the investigation.
The police of
No, that inquiry was not a party.
No, how is it not, sir? Because they had made a complaint with the police department, murders. That was some police officers murders. So we had conducted independent inquiry murders.
Put on NMD.
You get law on.
Covered that, lordship can.
Okay, we will.
Yes, my lord.
This is the remission, your lordship. At 22 years, I have served for 22 years.
Yes.
Who's convicted of the appeals are dismissed by the Honorable Court also. The opinion convicted court is pending, so I am seeking 2 weeks time. The opinion of the judicial opinion of the convicted.
Put a walk waiting.
Assessment for
Still pending. But it was verify the.
Put up.
agenda.
Put that here. We'll admit it.
I want, it might, if subject, if for one of the subsidiaries, they have accepted that we are entitled to treaty benefit. If that is the case, the Indo-Mauritius treaty
Mauritius
benefit,
treaty.
in which case that would not matter, can be discussed now.
So, after it.
After.
So done it ASB.
Right.
Got item number 49. Issue through publication hearing first time after notice. Kindly afford me to file a reply. It's a short issue, my lord, so many short date.
Of law, whether this any remedy to this coup. I will find a suit. If the appeal was filed, appeal was their appeal. But if the court holds, and then the provisions provided under Act and the rules, it's a remedy and says suit was not. And this was all.
Anyway, we want an opportunity to.
Under section 22.
Is there a clear ouster? That's what he's arguing.
There any matter incidental to or not related to the honest and rules notice clearly passed. So if the suit is maintainable.
Recovery of fees, you can't oust something not provided in the act.
No, it is not that. It is prohibited, my lord. It is not that the act is silent. I can understand, my lord. 22 says, my lord, the specific one. Secondly, my lord, to make
The land constitution of the respondent 4 weeks time to file his counter. Put a walk to 4 weeks. On a
so ridiculous. Ridiculous.
I'll tell you a lot.
we are told NMDS.
The difficulties were the boys have not paid together. Then the school doesn't say. After 6-7, they were fine. Were dismissed. And now the students pending in court, they say you get an order for, and then only would proceed in those students.
Wait for 4 weeks.
Grateful.
Work up the law, Mr. Tiku, because we need judgment, whether it's ouster, implied, Dulaba.
July, handful of 1968, the state followed. If your lordships look jurisdiction question, 22, it doesn't apply. Says that the government, if they do any action, I can't find the food. Find the food. Nothing to do for the income.
Claim to be actionable one melon. There is a followed by every school. Not followed now. So make no set of now.
We have
You
it.
can
I file a compilation.
Yes. May I request for a copy of petition? Application cannot, so copy has not been served.
You give a copy to.
Please. Absolutely.
It's here?
No, he is starting to.
Put on it.
Great.
He has actually become infectious. So the gentleman died. The wife cannot step into the shoes of the gentleman otherwise.
I have to speak first, Mr. No. The question is this, madam, if the first petition, petitioner's husband was appointed against the vacant post. Here, no contestations have been carried out, which provided that, and he died in harness, thereafter 50.1, she was appointed as a compassionate appointment. But even if the first case goes, but my submission with great respect is Mr. Poonam Shukla. She is a widow, she was appointed and merely because the petition was dismissed and therefore I was terminated. But kindly have what the rule, they just pass.
I've done an NMD.
She will have locus standi because her compassion appointment depends on.
She has submitted a transfer here, that it can be this matter. She cannot take any.
That petition is an application that has been transferred. We have already been transferred. By petition. And the rule itself said, madam, like the.
Third net.
Can be 50 date, some date.
Lord's the thunder, madam, Lord's the revision of the reservation list. And your lordships have held 32 years back. There is a specific law, Kerala law, which says that every 10 years it has to be periodically revised, Lords. Because going in perpetuity, Lords. Your lordships have recently had that constitution overruling that Devinder Singh judgment also. Your lordships have said. So the idea is this, Lords, that every 10 years there has to be a revision of the. That does not happen at all, Lords. There's a thin volume, Lords, which I find just 10 pages, Lords.
How would it be, how would I want to condemn?
Then, Lords, what happens is that, Lords, I told you, I came under 32, Lords. I said that this directions under the judgment in Indira Sani is not followed. Go back to High Court because it is state specific, Lords. I went back to High Court for the specific direction. Yes, and say with these directions, your lordship said enhances to because I am basically on the compliance of your lordship's judgment, Lords, in Indira Sani, Lords. Lordship just have this 10 pages, Lords.
Who appears for the respondent?
The state, Lords. Because one is blaming the other, Lords.
I'm not blaming. You know, India to one. The order of your lordship. Especially petition was dismissed, however, Jan was extended by
28/6.
yes, 28/6. This was the direction that the Union of India took.
Now, Lords, please see the counter filed by the state. In the counter filed by the state, Lords, at page 80, the state says that they have got socio-economic survey from the central. But despite that, they don't want to do it. Because these are repercussions, Lords. You are revising a reservation this existence for 75 years, Lords. Now, there is one person getting the entire benefit of the reservation, inadequacy of representation with regard to the other caste members. That is
And that is, the state has to do it on the basis of a quantifiable data.
and millions for that. The legislation does, it says,
Since this order was passed in the Indian matter, let them come. That's all we're not having.
I prefer to when the AC was on in another court,
I have done some other. Who is appearing?
Mr. K. Nataraj.
Here, is also appearing in that matter.
yes, no, he appeared in that matter also. I think, you know, it's unfair. Chief Secretary to come online and say, you know, as to whether they intend to imply the Kerala Milords.
Mr. Gupta is very much here. Why should we?
Because they cannot implement. Your lordship direction as well as in legislation.
After vacation. Second day of January.
You should notice in this matter, on 2nd of December 2022, this month, your lordship, that in the Godavari project, irrigation project, there are underground pipelines there, double pipeline, single pipeline. The work was going on, the land was not usable, therefore compensation was paid, rental compensation. After the work was completed, they filed a petition saying that no land must be acquired and it was. In the meanwhile, the government of Maharashtra came out with an act to pay compensation specifically in such cases. We followed that and gave compensation. Despite that, they are cultivating the land, para 17, page 16. They are cultivating possession, but because the land is not buildable, they can't be used for building houses. Therefore, you must acquire the land and give compensation for consideration before lordships. And now, in the meanwhile, despite your lordship's notice, they have filed a contempt petition and contempt notices have been issued against the offense.
Who is appearing? Who is responding?
I appear for respondent, brother.
Yes, Mr. Gandeshwar.
My lord, this is in possession was taken from us. And my lord, the act came in 2018. The High Court has held that this will not be applicable retrospectively.
No, the possession has been taken permanently or for a temporary period.
Temporarily.
But no, it is taken permanently because this has become unbuildable. No borewell, no is permissible, and this is NA land and NA potential land. This part also is considered by honorable. Would your lordship come to page number 18?
Virtually the land is drained of its any utility, Mr. Marlapalaya.
Yes. Kindly see para 17 of the High Court's order. High Court admits that they are cultivating the land. Admittedly, that is how the word starts. Para 17, page 16. Now they say because for building construction.
No, where is the cultivation?
Last end, they are cultivating the lands. Well, admittedly, the budget 2010 for laying pipelines. Rents are being paid to the petitioners after taking the grant. It is the contention of the respondent. The work of laying down underground pipe have been completed, and the petitioners' landowners are cultivating their agriculture. They are cultivating, is a fact.
But if your lordship comes to the
and therefore it can't be used for building houses, and therefore it must be acquired. Consideration we hold was issued way back in 2022. Now, rather than waiting, the more contempt the officers. The issue is under for more than 5 feet down from the surface level.
No, but then the proviso to subsection 1 that the such owner or after the declaration under subsection 1 of section 4 of construct any building or any other structure.
Yes.
Or any time.
Yes.
Well or reserve. Any tree on the said land, so it becomes virtually of no use.
No, agricultural activities can continue, trees cannot be planted, and building construction can be. 2018 Act is dealing with specifically for this. The legislature felt the need that there must be some must be given to the there is some disability, namely planted or construction cannot be undertaken. It's 5 feet down the more than 8 feet. Therefore, there is no impediment in carrying out the agricultural activity. And
Make the corridor.
you just no problem, but in the meanwhile, contempt notice shall come.
Maintenance will be easier. Is
It is not
taken-
fenced, it's not fenced.
not laying an underground pipeline. And you see, on top of it,
It is completed in,
suppose you have
there is no maintenance manual. And even if sometimes you have to go case, they have to attend.
yes.
Will also be right. They will go and only, that is why there is a disability. That is felt that it must be addressed and they must be paid compensation. Compensation has been calculated. 14 farmers have been paid compensation ranging from 15 lakhs to 50 lakhs. Meaning said that no.
No, but how does the electricity operate now with undergrounding of the wires?
There is a
I know, but
They shall be
Now, this arises out of my writ petition was allowed and order of just confirmed by the division bench and your lordships by dismissing confirmed. Please note on 16th of 19, the LPA of October 2019.
16th
19. There is not SL of October 2020. I'm sorry. 26th of October 2020. The review and LPI is filed on 7th of 2022. 7th of October 2022. So we got almost less than a month for 3. At page 52, 50. But this is their explanation. Not the, they say that 4 days. Please see below the explanation. Though actually it is much more than 1,000. Page 50, para 3. The Lordship got that? Page 50.
Yes.
Yeah. That the copy of the judgment and order dated 16/10/19 was received. Thereafter, department undertook necessary seeking legal opinion of the concerned assistant government bidder. Thereafter, necessary by the department for seeking necessary approval and sanction for preferring special leave petition before the honorable after communication dated 1/1/20 informed the advocate and order dated so para 4. Applicant states that the department thereafter in the concerned advocate before the apex court on 2020 since all necessary papers were not forwarded, same were called for advocate on record had called the officers from the department for meeting and deliberation. Preparation of memo of appeal took a couple of days and the stated tally number so and so was filed. Thereafter, with a resolution dated 23/4/2000, Solicitor General was appointed to represent the case. The Honorable Apex Court judgment dated 26/10 dismissed the special leave petition. And here starts the lot to know. The applicant stated that on account of pandemic of 19, which was rampant at the relevant time, immediate steps could not be taken at the end of the applicant's 26/10 to 6/6/2022. Lord, COVID was much over. Your lordship started open hearing court in October 2021. applicant state that the Panchayat department forwarded the proposal with the legal department on 10/6/2022 for preparing review application. The legal department with a communication dated 23/6/2022 initially rejected the proposal forwarded by the Panchayat. Thereafter, the Panchayat department forwarded a proposal in the forms of noting before the Honorable Chief Minister state on 27/6/22 for preferring review application. Again, the judgment and order dated short. So, through the channel of submission, entire file for seeking approval and subsequently necessary to prefer review application. With a communication dated 16, it was 16/7/22, informed to the Panchayat department that necessary approval is being given. Thereafter, Panchayat department, and then Lord, they say that the 304 days. Here it is not written at page 7. Honorable High Court 304 days delay is condoned. Judgment of the High Court. Something which is concluded way back in 20. After a delay of about more than 1,000 days, Lord, that the review is maintainable after dismissal of the SLP. No difficulty about that. But Lord, the reasons given and Lord accepting it as a 304 days delay, and therefore, that should also. Please have a look at the. Lord, page 5 at the bottom. Last paragraph. Learned senior advocate so and so appearing for the opponent vehemently oppose the application on the ground that here is a case in which the order passed by the division appeal is confirmed by the Honorable Apex Court, and after delayed period, the review application is sought to be filed and maintenance application is also. The civil application may not be entertained since the order passed reconfirmed. It has further been contended that here is a case in which it has not correctly stated the facts.
And the order of the High Court is already implemented. Applied.
Yes. 304 days delay is stated to be.
If order is already complied with, then what gives?
No, but they want to pursue the review application. To hang on me. Issue notice and the basis is 304 days delay. If they say that you will not be disturbed, you may on principle file. I have no difficulty.
Are you willing to make a statement that the respondents would not be disturbed?
Unless I can seek instructions on that, that as far as they are concerned, if they are not, we can proceed.
Yes, on a question of law, we will permit the review to be over.
Yes, what? You doctor, when a similar matter has come out. Many started fighting, and I tell you, doctors, it's important for your doctors to know what the background implications, which are huge, but that alone can't be an explanation. And the issues in there. Now, this is my lords, your lordship's order. So seeks permission to withdraw these petitions and liberty to file a review. My lords have that High Court, and in the event the petitioners do not succeed in the review, to approach that court granted, special leave are accordingly disposed of as withdrawn. Find that the order passed by this court dated so and so, which is the order in this matter, be construed as taking the review proceedings. Now today review proceedings are pending, and I tell you what has happened in these matters is, my lord, we have 3 judgments in our favor as far as the Gujarat High Court is concerned pertaining to contractual employees in our favor. One judgment in Jagtiani's matter came with regard to ad hoc employees, who was a completely different form of recruitment, who after 2 years, these contractual were only for, there was no condition provided there. Now, after the Jagtiani judgment noted that there is a difference between contractual employees and ad hoc employees.
Anyway, take.
Very well. I seek instructions as to whether, as far as they are, will not be then used against us by the others. If we make
No, you clarify that.
yes.
That
I'll come back on Friday. I'll come back.
Monday.
I'm a 6 original petitioner, my lord. I had filed one item, but we were not. That is IA 137-355. I want to withdraw that. Because I have already placed my counter affidavit on record. But we are similarly situated.
Okay, allowed to withdraw.
Yes.
Yes, yes. Fine.
But there are two things.
But since then the rules.
Since then, my amended. After that, ordered and took the exam and have been regularized by taking an exam. So that stage is over now. The problem here was completely different categories with 3 judgments and one pertaining to ad hoc employees, which is a separate category. This filed by them after losing in 3 and that one judgment of ad hoc employees. But the contractual matters without any application, then the facts are completely different.
Take this.
Instead of Monday, we have 7, we got on review. Other from
Entire week. Friday.
Right.
Grateful. Very. Very supply.
With my lordship's kind leave minutes, I appear online.
That's
Sitting here.
in this matter, reflection.
We'll have done.
Great.
Minutes, may I just submit 1 minute without obstructing your lordship? Minutes, it's an order based on consent, and they're still dragging us.
And then they were near the
Kindly see at page 9.
Mr. Sehadri, we have this.
My lordship, kindly have a look at page 9 minutes.
No,
Where
already
they've
told
consent.
we have to hear them. And there must be some reason.
So be it, minutes. Any other sufferings which were in industry, where no electricity connection, were paid the under protest. Kindly have an early date, minute. That's all my prayer is.
Immediately after.
Minutes, deeply appreciated.
And just take me a few minutes. Order of 17th May 2024. Paragraph number 8. Your lordships had said, observe anything with regard to the order dated second.
I have
17th.
I submitted the calculations, how much
I'm telling
he's
you.
taken 3 and where the people closest to him have not been promoted with this.
I'm not on the question of promotion.
He's claiming those, we have reasons he was AWL, we stated we've given 36 lakhs according to giving around 5.5 crores.
More than that.
Well, this is out of
NMD.
May I just request your lordship?
NMD after vacation.
Millard, at least.
We'll give you vacation.
Millard, can it be next week, Millard? He's really hard pressed for money, Millard.
Immediately after vacation. Whatever you, according to you, he is entitled, you pay that off to him.
Millard, my entitlement is 1 crore and 70 lakhs.
Okay.
So Millard, may I just request your lordship to kindly give me a short date, Millard. Millard, fixed date, Millard, in the
They will give the date you are told.
in the month of January.
Only from 30 the October.
13.
Only one IA is listed today.
But then I find difficult to convince myself from logic in the petition. In fact, to challenge the provision act, we lost the issue of mandamus to the government. Parliament should amend the law and things like that.
Let the petition be listed along with this.
So
My application, there are two applications. I saw that one application by virtue of the 7th of January 2021. What remains for me is verify the certification of the AR.
2597.
That's correct. 25975.
They want a court intervention.
Have some difficulty now. This kind of substitution, how does it really happen?
How can we grant such a relief?
For substitution of AR?
No. Main relief in the petition.
The petition is not in a listed form. Here only comes to
List of application along with the main petition.
Right.
And item 56, my lord said, granted status on the property. They started construction, my lord. I filed a contest that they requested for some time to file counter affidavit in the main notice in the counter petition.
I'm sure we not file counter. There was a change in council. That's the reason that the counter is ready. So the date to dates.
Yes. One of the learned says that the counter will be filed during the course of the day.
8 is a short. Working date by order dates before court 3.
We'll have it in the next.
Because they have it for
Next week.
next week. Lord, may I make one question? Would your lordships stay the elections in Rose Avenue Court alone? Because what is happening there? Lord, I was in that case till the next hearing alone, more than not because the bar council.
Is the election notified in the week?
No. Notified.
In the next week.
Not any date. Lord, I should 10 minutes for this. My points very. Your lordship could have it also subject to.
The number for Bar Council of India also, Your Lordship.
But the arguments legal. Nothing more. I find my summary also.
Okay, so we'll have it.
Yes.
Great for you.
For responding to now on Saturday, my 2 Miller instruction to.
When do you want? After vacation at the request of the consul.
So great. But my parents will be taken because my
Joined?
Communication from responding but who was wrong. That's it.
What happened? Seat was to be given as per the last order.
Respond number 2. Who is applying for respond number 2? Take instruction, we'll have it tomorrow. Take instruction. Order has been complied with or not.
Your Lordship, I think you need also Union of India would appear for MCC.
Who is applying for Union of India?
Union entered.
Gaurav Sharma appears.
Mr. Kaushal does not appear for Union. Served through learned AS for Union.
Plenary ASG. No copy to Mr. Banerjee. They have to tomorrow. Inform him that we'll have it day after tomorrow.
That's my humble apologies for so. Well, accused in 2 crimes. Friends have taken a plea.
Wait for
Yes.
Point is very.
All that agrees that observations in third parties petition should not have. Because
only
proceedings are pending.
the petition is that of the High Court in the impugned order prejudicially affect the rights of the petitioner in the proceedings against the petitioner. Observation. We clarify that the High Court in the impugned order would not adversely affect the proceedings.
Grateful.
Okay, then on the second occasion,
Did not do it.
I'm sorry. It's in the room which happens.
No, you don't get the word obvious reason.
and then
There's a 670,
what remains?
the lawyer passed an members, and they have to be considered.
For 2019.
What happens is this is causing against us, and
Not restored. This will be taken on file. We are not intending to interfere. The question of law is kept.
what has happened is, pursuant to that,
Liberty to withdraw with liberty to take such steps.
50 members will have a right.
You say the bullying. Such steps as are permissible in law.
Permission, I don't know, the
बैठेगी तो दीपक जी दीपक जी दीपक जी